Good morning. Good morning, everyone. If the members could take seats and we could have order, we'll go ahead and get started. Um, I'll go ahead and offer our prayer this morning. If you please join me in prayer. Dear Heavenly Father, we thank you for this day and this opportunity to work on behalf of the citizens of the state of Georgia. And we ask you to guide us as we do our work. Amen. So the first item on the agenda here today is House Bill 426, which is in the folders. And I'll at this time turn things over to the Vice Chairman to preside for the hearing on that.
Thank you, Mr. Chairman. And I guess first off, normally we recognize judges at the beginning of a hearing. Are there any judges in the room right now? I know we have some elected prosecutors. Okay, so we are here on the chairman's bill, House Bill 426, LC 470124S. Is that the correct LC number? Okay, here, let me turn you on. All right, Mr. Chairman, do you want to, this bill was passed by the subcommittee yesterday evening. Do you want to go through the bill and tell the committee about your bill?
Yeah, thank you, Mr. Chairman, members of the committee. I bring to you today House Bill 426, which was passed yesterday in the Reeves subcommittee. Georgia's hate crime statute was found to be unconstitutional by the Georgia Supreme Court in 2004. That was in the Botts case. And the issue was the individual targeted was not identified. The individuals targeted were not identified in the statute. And so therefore, there was effectively a vagueness issue with the existing statute, and it was found to be unconstitutional. This seeks to address that with revised provisions here that also mirror existing statute in many of the 45 other states and the federal government that have similar statutes. I'd be happy to answer any questions.
I did actually have, and I should have asked you about this beforehand. This is just more of a clarification than anything.
Sure.
In line 23, this is the misdemeanor offense. I know there's two. There's the misdemeanor and the high and aggravated. And the misdemeanor would be 3 to 12 months. And the fine not to exceed $5,000. So that's not a minimum of $5,000. Is that correct?
That's correct.
Because I know a lot of times we see in misdemeanors with a 12-month sentence, in practicality in court, it's hard to. It's usually unlikely that a person is able to pay a $5,000 fine within that short of a period of time. But this is set where it can be below that, and the judge has discretion up to $5,000.
That's exactly right.
Okay,
Yes.
Just wanted to clarify that and make sure that I understood that right. Are there any other questions or comments by members of the committee? Okay, Chairman Setzler.
Thank you, Mr. Chairman. I'd like to thank the gentleman for discussion yesterday. I'd also like to apologize to the committee yesterday. I was really not prepared when this bill came up yesterday. With the hullabaloo, I really didn't feel like I was able to represent different opinions effectively. So I apologize for that. I do want to ask though to the chairman, my good friend from Gwinnett. I had shared, at least introduced the idea yesterday of a concern around these enumerated classes, and I understand we're sort of weighing out in the broadness of this how we can not be void for vagueness, but yet accomplish something. And I think my concern is. The impetus for this was the idea that these actions don't stand by themselves. These actions really, the reason we would want to put a hate crimes structure in our law is that there's this sort of calculated fear effect that's broadcast across a class of people. And that really is why we're doing this. Is that fair to say?
Well, that's one reason, and it's not the as I told you yesterday, it's not the explicit reason that's provided in this bill, right? But I think that is a type of danger or harm that exists, and that this bill is a step in the right direction to address that.
Yeah. Because my concern, Mr. Chairman, is we think about an act that casts fear in a group of people. What is it? I mean, if someone commits a heinous crime against an individual that's not that has malice aforethought and all the elements that's required for criminal intent, and then another act to someone else that's the same, this is being treated differently because the motivation for the hate is a skin color based animus versus an animus that's could be based on any number of things. My concern is families. There's widely known circumstances where in organized crime or otherwise, someone attacks somebody because of their family members. I'm going to come after you, and I'm going to come after every member of your family. The message is sent: your family's not safe because of the job you perform, or because how you're positioned in your responsibilities. I don't know why familial relationships wouldn't be a class here, because again, I think that the cause and effect of going after somebody and casting terror across their family because of something they did is a more coherent and perhaps realistic circumstance and effect than the enumerated classes in your bill. And I think that there's another thing that I think affects people's underlying rights, perhaps even greater than that, but from a familial perspective. If someone's house is tagged with graffiti that's provocative, or someone's personally attacked, that casts fear across the family, how is that different than one of these enumerated classes?
Well, I'd have to really evaluate what you're raising here, but my response would initially be we have specific laws already with respect to individuals who are past or present spouses, individuals who have children together, special sentencing availability in those statutes already, family violence battery or similar family violence types of offenses. So at first reflection on your question, we have existing protections for, say, violence in the family type situation.
Well, if an employee, for example, were fired by their boss, it's a right to work state. I think it's one of the things that's great about Georgia. We're right to work. I think that helps us. But let's say somebody were fired from their job, and the boss that did the firing, their house gets, or their property gets, their tires get slashed, or there's a message that's sent. Again, it may be a misdemeanor act, but the idea that you're casting sort of terror across their family, or something's even communicated about you better watch your family, and then an act of violence, maybe a misdemeanor act of violence that casts a broader cloud across their family. That's not addressed in this.
I think I understand your question. So if
Sure.
I could respond. So as I was saying earlier, you and I had a discussion yesterday in your questions about these types of offenses being maybe more broad in the effectively the threat or intimidation that's communicated through the act to a larger group. But as I testified yesterday, this bill is really confined to the victim and its applicability to the victim or group of victims who are directly targeted in the criminal offense, as I read the language. And so while I understand your question to be if there is a broader policy objective, then your bill might not fit, the language might not fit that broader policy objective. What I'm saying is what you're requesting is maybe different from what this bill does. You saying that an additional class might be necessary for a different type of bill is more broad than what 426 really does in its application.
But my point is that as a class of individuals, it's clearly defined. Family is a definable, understandable social construct that there'd be some sense of kind of membership to, that people would have an affinity across, so that an act of terror, a hate crime could be focused on a family in a way that I would argue is more credible than even perhaps these classes. I'm also concerned secondarily that if you think about classes, we talked about ideology or even political party. It's not just limited to the idea of wearing a Make America Great Again hat or a Change T-shirt. I mean, we're talking about the ability to chill people's voting behaviors. You know, you come to the polls, that's sending senses that, hey, you come to the polls in this precinct or in this county, you know, your political ideology is not welcome here, and there may be a threat that's associated with it. I mean, to me, if we're going to enumerate classes, I think we do well to think about this and say, wait a minute, ideology, political affiliation is not just a matter of feeling and, oh, they hurt, my feelings are hurt. But if we're going to take this approach with enhanced sentencing for enumerated classes, I can't imagine we would leave aside family. I can't imagine in this day, heaven forbid, things get worse, we would leave aside political party or political ideology, because the very clear and direct impacts that can have, not just on people's feeling of safety and security, but people's ability to exercise their franchise to vote. I think there's some very clear, I mean, to me, that might even be more beneficial from the standpoint of class than some of these. And if we as a legislature are going to address those, I think we need to do it in a broader way, whether it's through 161137, terroristic threat or act. There's a structure today in our code to do that. And I would just challenge the gentleman that the hate crimes approach to this doesn't solve those very important things in ways perhaps we need to step back and try to address.
Well, as I said yesterday, gentlemen from Cobb and I have a long and great relationship working on legislation, working to perfect legislation, and I sincerely appreciate all input on any bill, this and any bill that I carry. And sometimes legislation that's brought, and we see this many times in this committee, legislation that's brought, we say, well, maybe there are other applications that ought to be considered, but that was outside of the sponsor's original presentation of the bill. And so maybe the best avenue for that, if a member feels that way, is to bring legislation to see that member's concerns addressed as well. But also in subcommittee, we, on I think a different point, said we'd have to agree to disagree, and if that's where ultimately we end up on this, my respect for the gentleman will not change. So,
Representative Kendrick, you
Thank you, Mr. Chair. To confirm, there's already a federal hate crime statute, and so this is based around the statute that we already have federally. Is that correct?
it's similar to
Okay. And secondly, because of the items that are in lines 18 through 19, would it be your opinion that a lot of these are based on historical attacks? So when we talk about familial attacks, literally I don't know anybody who has necessarily been attacked because of their family, only in movies. But I can name many a victim who has been attacked based around the things that are already enumerated. So we have a history of people already being attacked based on these items.
So as this legislation was prepared, we reviewed protected classes in other statutes, in other states, and in federal law.
and tell me if I'm wrong, but I think that whether or not there's a concrete example available or not, if somebody, we are all elected officials and we hold positions and we take stands, and if somebody were to, attack or intimidate my wife because of position that I'd taken, is that in the spirit of what you're referring to in the familial?
That's precisely what I'm talking
And
about.
I think that's something that, while we may not have concrete examples of, it's something that could very easily happen, and certainly probably has happened. But I understand that the structure of, frankly, this list is a very the list that's enumerated here is seen over and over again in states and in federal law. As it relates to this hate crime issue, is that right?
Yes, sir.
Are you aware of anything in the research that you've done on this that includes, the type of, I guess, additional class that Chairman Setzler's referring to?
Yes.
Okay.
And
yeah.
Mr. Chairman, to the lady's point and to yours, in 1611-37, the Terroristic Threat and Act, because of that issue, there is a provision that deals with judges, police officers, and I could read it, but that because that there's a recognition, the family and associations are a target for those kinds of folks, and we've spoken to that specifically in code. I believe there's a circumstance, though, that is, if we're going to delve into it here, we do well. In fact, we do better, I would argue, to follow that structure and recognize it's not just police officers, judges, DAs, and the like, but that through other relationships, that people's family is a basis of a threat. You can probably intimidate me more by threatening what you're going to do to my family than me. So I think it's as we take this seriously. I mean, I appreciate the gentleman's concern to send a message, but I think as we do well to not punish thought once the threshold of malice aforethought has been crossed, the specific motivation of that that leads to a heinous act should be punished for the act itself. I don't know that we should then step back on the other side of what is the source and the flavor of the malice aforethought, and that should be punished more severely because of the nature of the thought. I think that's in essence what we're doing here, and I think we do well to focus on the acts themselves and take a rubric from 161137 and address it that way. And I think your objectives can be accomplished that way, Mr. Chairman.
The problem with the kind of the catch-22 on this is that the prior attempt of leaving it open or undefined was struck down, understandably, as void for vagueness. And we understand that doctrine on this committee and the practical impact that it has. But then the problem with a list is you're always going to have somebody that's left off the list, right? That's the problem with a list. Every time you make a list, there's going to be some fact pattern somewhere that something's going to happen and it doesn't qualify. And we don't see that just in here. We see that in every type of legislation that the craft in this body is with lists. But I'm going to go back. Is it Representative McLaurin? Are you? Yes.
Thanks, Mr. Chairman, and thank you, Chair Administration, for being here at your own committee. I guess I just want to clarify what the nature of the harm here is, and I appreciate what you were saying about this bill targeting the harm to the victim directly. Would it be fair to characterize that harm as an injury to the dignity of that person as a full and equal member of society?
So any attack on a victim based upon the classes that are enumerated here is unacceptable in society and should receive, I think, consistent treatment to reflect that in the law.
Would it be fair to say that the reason for inclusion of these terms, potentially, in other sources of law that identify protected classifications is that, again, to Representative Kendrick's point, historically, attacks based on these classifications have had the effect of injuring a person's feeling or sense that they are a full and equal member of a broader society?
So this committee has not heard testimony about the extent of previous incidents in Georgia specifically, but I think nationwide states and the federal government have acknowledged the need for legislation in this area because of specific instances where victims were targeted based upon being in one of the classes as enumerated here.
Okay, that's all I have. Thank you.
And Representative Kendrick, did you have something else? You're flashing. Okay, you're up.
So two things. So I guess I'm confused as to Chairman Sessler's. Is he advocating to include familiar as a crime, or just totally against the bill? Because my point in making that I haven't seen any instances in which a hate crime has occurred because of somebody's family is, to your point, when you make a list, obviously you're going to leave people out, and so it doesn't mean that we shouldn't pass hate crime just because one item is not listed, because like you said, there are other bills and other pieces of legislation when you start making lists that are left out. So I just wanted to clarify, I wasn't saying that they don't happen. It's just when you start making lists, something is going to be left out.
Mr. Chairman, it appears we've kind of moved away
I
from the
agree,
question
yeah.
portion into the debate, and so
Agree.
it's all right. If there are no further questions, I'll go ahead and stand down, and you can chair for the for this issue.
Okay.
Yeah.
Sure. So you want to make your way back over?
Yes, sir.
And Mr. Chairman, as we're transitioning just very briefly to the lady's question, the root of my concern is the premise of how this bill works is to step back behind malice aforethought and look at the nature of the thought and punish that, to the lady's question. I think the overall structure of that is we do well as a state. I think we've done well, and I'm proud of our state for not having criminalized that heretofore. I think we do. I think we stand in the minority of states in having been right on that. I think the gentleman's concerns, the policy objectives, and the protections that he's seeking to accomplish with the bill can be accomplished through a 16-11-37 structure that exists and is valid. But I think the approach to the bill is it sort of be a start over and approach this through a different, I think, more constitutionally appropriate. And I say constitutionally in terms of I know the federal statute's been upheld, but within our structure, a more appropriate structure. But I don't want to rediscuss that. I just wanted to be clear. I don't support the approach to this as a proposition.
Okay. So, is there any discussion amongst the committee right now? And we didn't have a sign-up sheet, and we mostly deal with this in subcommittee with public comment. But is there anyone here that feels extraordinarily compelled that they would like to add something that in 30 seconds or less? And if so, then now would be the time. Is there anybody in the audience that would like to say something? Okay. So seeing none, no further comments or questions from the committee. So I guess that would leave us at, is there a motion?
Mr. Chairman, move to pass by committee substitute.
Okay, there's a motion by the minority leader, and there is who seconded? Seconded by Representative Kendrick. So there's a motion to pass in a second. Are there any amendments for this bill? Seeing none, the motion and the second, so I will call for a vote. All those in favor of the passage of House substitute for House Bill 426 LC 470124S, vote by saying aye. Aye. All opposed? No. Okay, the bill passes. Congratulations. Yeah, I'm not in charge anymore.
All right. Well, thank you for letting us take care of our business first this morning on a bill. Crossover day is next week, I know, so legislation is moving very quickly right now. To recap, as committee members are aware, last Monday, the Supreme Court of Georgia rendered the Elliott versus the state opinion out of Clark County concerning the admissibility of a refusal to submit to the state-administered breath test at ultimate trial of the offense. And as a result, this is the third hearing that this committee has held on this issue and a potential legislative means to address the admissibility of a refusal to submit to a state-administered test. And so here today, and to give you the background as well, we've heard from Legislative Counsel, the GBI, we've heard from prosecutors and the defense bar on this issue, and we've also heard from others who are very involved in these issues. But it's an incredible honor to have with us here today the national president of Mothers Against Drunk Driving, and if Helen Whitty would please come forward. It's a great honor to have Ms. Whitty here in Georgia today to offer testimony, and if you would please have a seat there, ma'am. We would appreciate, thank you so much for being here with us. We'd appreciate to hear your testimony. If you wouldn't mind pulling that mic over towards you. I'm sorry, yes, ma'am.
Okay, great.
If you would just introduce yourself and then share any testimony you might have, and finally we might have some questions for you. Thank you.
Okay, great. Thank you. It's a great honor to be here. I'm a native Floridian, and I drive by this Capitol all the time. I'm here in behalf of Mothers Against Drunk Driving, and what we want to see happen is all drunk driving offenders receive an ignition interlock, simply because this is the technology we have here today and now to remove the drinking from the driving. This is something that can change behavior. It can allow an offender to keep living, to keep driving, just they can't drink and drive. It's proven that this reduces recidivism by 67%. It saves lives by 16%. I frankly don't understand why this is such an issue. The difference between a DUI and a DUI fatality is that. And I'm here because my daughter was rollerblading on a bike path on a bright, sunny June afternoon, and she was run down by a drunk driver on a bright June sunny afternoon. For the last 2 decades, I have walked beside families that have been shattered by this violent crime. My daughter's skull was fractured from ear to ear. Please, this is a way we can remedy this, what's happened last Monday from what you described. It puts the drunk driver's rights above the rights of innocent people traveling Georgia roads. So I am, MAD has worked on ignition interlocks in every state for all offenders. This is it. It's small. There is, if we have a person who can't afford it, there's a part that will help it be afforded. This is a way, the technology we have today that can save lives today. And I just am, you don't want any more dead people for no reason. You know, this is 100% preventable crime. Thank you, Mr. Chairman.
Well, thank you for your testimony. I have a few questions, if that'd
Yes,
be all
sir.
right. The ignition interlock, would you just describe what your understanding is of how that works?
Sure,
and
I'd be
maybe-
happy to.
Yes, ma'am.
I actually have also worked with offenders who are on it. So it goes in the car. They go to a vendor. They get it in a car, and before they can start their car, they use this. It's a little breathalyzer that goes everywhere with you, and it's on for a certain amount of time. And then if they have alcohol, their car won't start. So that's the miracle right there. If it retests it after 5 minutes, say you take a breath mint or something and there's a questionable, but what's really neat is we have this, and in the past 12 years, 30 million attempts to drive drunk in this country have been stopped. So it is working. And then for a certain amount of time that they have it, then they go and have it removed after a certain amount of time. So it's a great little device. At some point, also they will retest while they're driving. When they first came out, again, the people were saying, "Oh, somebody else can use it." Now there are little cameras, so that it's certain that the offender is not having somebody else use it. So there are things that are working that make it effective. It's what we have today. I just think we should do everything in our power to have this so that we can save lives.
All right, thank you. There are a few questions from the committee. Vice Chairman Reeves.
Thank you, Mr. Chairman. Thank you for being here. What is regarding the cameras, and how is it verified that does it have the face recognition software, or is there somebody on the other end? How does it verify that
I'm going to have to talk to my expert. Okay. Oh, here it is.
Yeah.
Right? Okay. Now, is it eyes? Or is it the face recognition?
you can have a seat?
Oh, can I?
Okay. This is
Okay, sorry.
our expert, Frank Harris,
All right.
from our Washington office.
Can you
Mr.
pull-
Harris, if you just pull the microphone outside over to you and just introduce
Sure.
yourself.
Mr. Chairman, my name is Frank Harris. I'm the Director of State Government Affairs for Mothers Against Drunk Driving.
Okay.
And I've been pushing ignition interlock laws, including here in Georgia, for the last 12 years. And I know Representative Setzler was a champion for the last reform efforts, so we'd like to thank him. But the camera unit, this is what it looks like, and there's actually a demo vehicle right outside right now. So a camera, it's mounted onto the A-frame, and then it's just another anti-circumvention feature.
So how does it verify? What's the verification process that the person that's blowing in it and that it's capturing in the photograph is the person that?
So there's different ways it can be verified, either on the back end, where if somebody has a violation that necessitates some sort of court action or administrative action by the DMV, or in this case the DDS, such as they violated their interlock order, and they say, oh, it was my wife who blew on the interlock. Well, they could look if it was the wife who blew positive, because they would have the camera image. So there's not necessarily facial recognition software tied in with it. It's just to verify the user and to also have another anti-circumvention feature.
Does it, I recently got an iPad. I'm pretty slow with technology. It's not my thing. But I got an iPad, and it has, for it to come on, it has the facial recognition software. So I just hold it up. I mean, literally, it could just take an angle of my face, and it recognizes me, unfortunately, and then it turns on, and that's pretty amazing to me. I've never seen anything like that. It's what would be the? I'm just curious, looking down the road. That's a pretty fantastic technology, and it seems like that it would be the perfect and ideal technology for what.
Sorry, Mr. Chairman.
Sure, yeah,
Mr.
please.
Vice Chairman, technology is how we eliminate drunk driving. And just to back up, as it relates to implied consent, the easiest fix to the implied consent ruling is probably allowing for the use of interlocks during the administrative license suspension period. That would be something that most likely would not be subject to any constitutional challenges. Birchfield from the Supreme Court said you can revoke someone's license, and then it would be separate from a criminal court proceeding. In 31 states, mandate the use of interlocks during refusals. Now, as it relates to technology, it is how we eliminate drunk driving. There's passive technology. Matt is cheerleading on, called the DATS technology, where one day, if you're too drunk, your car won't start, and it'll be an option. But for all we know, there's probably going to be autonomous vehicles, fully autonomous vehicles, where there might be a day where you could have a beer and drive because you're not driving. And that could be the future. We don't know. But technology is how we eliminate it.
So relating to facial recognition technology, is there any discussions underway to integrate that technology into this camera mechanism so that there doesn't have to be a verification process involving another person or a photo? It's just the camera recognizes the...
That would be a question for the interlock manufacturers. But again, I mean, the benefit of the interlock is it separates that drinking from driving, detecting of alcohols in the breath.
Sure, I understand.
Facial recognition can't do that at this time.
And so that we're clear, I understand that. I'm saying you've got a camera that takes a picture, and then somewhere along the way there's obviously some kind of verification process as far as the picture that was taken. Is that the person that's authorized to drive the car, or that is authorized to blow into the interlock? And what I'm saying is, instead of eliminating that verification by integrating a technology that immediately can recognize that is the person who has to blow into this in order to be able to start the car. That's what I'm talking about.
I'm sure the technology is there. It's just whether if it's financially
Sure.
readily.
And I was just
available.
curious if y'all had taken that step yet. So I'm done.
Okay.
So.
Chairman Setzler.
Thank you, Mr. Chairman. I appreciate the proposal. I don't know how it's played out in other states. I've got a concern in Georgia as it stands now that when people get a temporary driving permit, they're sort of living this fictitious life that you can only drive to work and drive to school, but you're not driving anywhere else. There's no other controls. One of the reasons I support this approach is that you've got actually from a freedom perspective, you're giving people the freedom to drive anywhere they want to, but you're having a technology to make sure they're driving there safely. I think we're in a sort of this mindset now where we say, okay, we're going to limit their access by only allowing them to drive certain places and believe they're going to follow that, but there's no real follow-through mechanism to ensure that's the case. Would you agree with that, currently in Georgia?
Well,
Yeah, I would just say yes,
Yeah.
absolutely. We know that on a suspended license, 50 to 75% of people drive anyway.
Yeah.
no matter where it is.
And I would also say, just for members of the committee that are maybe wrestling in this for the first time, I'd like your thoughts on one thing that was attractive to me in this is, let's be clear, blowing into a device is not a fun thing for motorists, and sort of the deterrent effect of the shame of doing this has an effect on first offenders, third and fourth offenders. They're sort of past that in their sickness. And I think the idea of doing this from the standpoint of changing behavior changes behavior more effectively when first offenders are required to use it than third and fourth offenders. Would you agree with that?
I would. I think they're all dangerous. And first offenders, they've driven more than 80 times before they're caught. But yes.
That may be the
yes.
case, but from the standpoint of changing behavior and saving
Yes,
lives,
and
it moves the needle more, I would argue, with
Yes.
first offenders.
Yes.
And just a note, Mr. Chairman and Mr. Chairman Sedgler, Insurance Institute for Highway Safety did a study on ignition interlocks last year and laws mandating the use of these devices for first offenders, and they found that they are 16% effective in reducing drunk driving deaths. And right now it should be noted that these devices are optional for people who refuse a test and optional for first offenders. And what Matt is trying to do is, if a person wants to drive on a first offense, let them drive during that suspension, providing they have an interlock, or they can't drive at all. And also right now in Georgia, there's not an indigent program for people who can't afford the device. So there should be one that's vendor paid, not state paid, so that everybody has the opportunity to use these devices, because this is a life-saving tool.
Vice Chairman Reeves.
Thank you. Hello again. This isn't really as much of a question, and Representative Bodie, I'd be interested in your, if you've had a similar experience, or Chairman of Stration. You know, in the last year and a half, when we changed the ALS laws and created the possibility of being able to bypass the ALS suspension by installing an ignition interlock, just as a boots on the ground practitioner, I don't do strictly DUI work. I don't do probably nearly as much as others even on this committee, but in the work that I have done as a private practitioner lawyer, everybody that comes in, we talk about the options. And I have yet to have somebody bite at the, you know, and y'all understand the way that it works. If you go to the ALS hearing, there's probably a 50% chance that the officer may not be there, and if that happens, then the case is dismissed and they go get their license again. Or if they're there, then they usually have to make an agreement, a contract, on how they're going to resolve their case in order to get the ALS suspension dismissed. And I have every client that I've had this conversation with has chosen to go to the hearing and see what happens. And I just present all the options objectively. In fact, I frankly really push the ignition interlock because, like, hey, this is the way that you can know that you know that you know that you're going to be able to continue driving. But I've never had anybody bite at it. I don't know if Whip Bodie or Chairman of Stration, what y'all's experience have been, but what do y'all say to kind of the consumer? I don't know if consumer is the right word. That's probably not the right word, but you understand what I mean, the resistance to this right now.
Mr. Chairman, absolutely. So if MAD had our way when we originally worked on that bill that passed in 2016 to redo ALS, we would have it where the only way you could drive during an ALS suspension is via an ignition interlock. And that's not the way it is. You can get a restricted permit. You can do other things. So, 32 states have laws where the only way you can drive during a license suspension period is via an ignition interlock. Georgia's not one of those. We'd like to change that. And that would also carry over into implied consent, because especially if interlocks are required for people who refuse a test for a year versus only 120 days if you submit to a test, people might be more likely to submit to a test. And then where MAD's been, we realize, if you look at the arrest to conviction rate here in Georgia, I'm guessing it's not that good. Maybe 70% of people arrested get convicted of their original charge, and I think that's a liberal estimate. I'm guessing it's more like 40 to 50%, depending on the jurisdiction. So if plea agreements are being handed out like candy, or at least in MAD's viewpoint, handed out like candy, why not ensure that if there is going to be a plea agreement, reduction in charge, or a diversionary program, let's include the use of an interlock to make sure that person is rehabilitated. And then also that person can be part of society and have a second chance at life because that DUI is not on their record officially. But that's one thing as well to incentivize the use is allowing people to have their records wiped clean, providing they kill or injure somebody on the first.
And so while we're here, kind of pivoting on what you just said, I want to make sure that I understand this clearly. Mad's position is that you all support the idea of a DUI diversion program that does not result in a DUI conviction, but in exchange for that, part of what the defendant would have to earn in order to complete that diversion is they would have to have some period of time where they have this device on the car. Is that right?
That is correct, and this has been a position that we have been trying. I mean, because even if we pass a judicial mandate today, saying judges shall order an interlock, we know that again, judges are going to reduce sentences. Prosecutors are going to make plea agreements. So we're going with the flow here. We'd rather have, as long as they didn't kill or injure somebody, why not allow a person to have a plea agreement that results, as long as they use an interlock, proving they learned how to drive sober.
So what kind of feedback have y'all received from the Solicitor General Association in Georgia?
Well, we were just invited here today, and that's an idea we want to raise with them. But, if we understand prosecutors have a lot on their plate, and we want to ensure that everybody who gets a DUI has an ignition interlock, and if that means if there's going to be a plea agreement or a reduction in charges, why not allow that, especially if that DUI can be off the record. And we know in other states, this has been an approach we've been pushing, and it's been palatable to lawmakers, it's been palatable to the offender. Because right now, if I'm an offender in Georgia, there's no way I'm going to go to opt to use an interlock, because I'll just risk it, drive unrestricted license for 120 days. So let's change the way that the system's working, because right now the system isn't working. 366 people were killed in drunk driving crashes in 2017 in Georgia. We have a long way to go to fight drunk driving. We got to get more interlocks installed.
And as a victim, I would say we have to have consequences. The death numbers, unbelievably, with all the other issues like Uber, Lyft, the death numbers are going up. They went from 10,000 to 11,000 in the last 2 years.
Wow.
They're going up, and on drunk driving. That's the thing. So many people, oh, it's marijuana, oh, it's this. It's alcohol, and it's killing people, and it's killing people randomly. So let's do what we can today to stop the killing.
Thank you.
Thank you.
Did you have any questions? Which number are you? Will you press the button, please?
My original question is probably not posed to Matt. It was about the indigent program, so I want to ask you all that, or unless you all are qualified to answer.
I think
detail
so. I
on
mean,
that.
we push these.
Okay.
In every state.
Well, because I think everyone can agree the primary intent for this is to ensure that we use adequate technology to make Georgia citizens who use their roadway as safe as possible, and I think that does accomplish it. But my only concern, and I think it's answered by that indigent program, is we don't create unintended barriers for folks to, after they make that unwise decision to be productive, to be able to go to work to and from. Could you describe, is that a indigent program a good faith measure that will be understood by us, or is that going to be written into the statute of it as part of it if we require it?
So, Mr. Chairman and Representative Saint, it needs to be written into the statute. At least roughly 28 states have indigent programs, and the easiest way to do it is make the vendor pay for it. And if the interlock vendor wants to do business in Georgia, they have to provide interlocks at a reduced rate for people who are objectively poor and unable to afford the device. Now, it should be noted, South Carolina has an indigent program. They don't have too many eligible offenders for it. They have like $600,000 in a fund that's sitting there. But it's better if it's up to the interlock vendor and somebody has a device. And we laid this out in our handout here on a sliding scale. And California, I put the Wisconsin method on how their indigent program is. But California, if you think devices are still too costly, because they cost about $3 a day. So for 6 months, that's $500. For a year, roughly $1,000 with all the other fees. California has the most liberal sliding scale indigent program, so that everybody has an option to get an interlock. And again, the key is that this cost wouldn't be absorbed by the state; it'd be absorbed by the interlock vendors.
And
Sorry.
I'm sorry. If I could just jump in real quick, I'm just thinking of it. So, and who decides and I'm sorry, I haven't read your material
that's
yet,
okay.
but who decides?
So the easiest one, and there's different ways to do this. The easiest way to do it is, some states have it where if a person qualifies for food stamps, then the interlock vendor must give them a reduced rate. Others just have it based on where they are at the percentage of the federal poverty level. And the benefit with that is the federal poverty level does change. So then you have to go back every 3 years to change what qualifies for urgency.
I'm sorry, Representative Sainz. Yeah,
No,
do you have a follow-up?
That was basically regarding how, when you say South Carolina doesn't have barely anyone who qualifies, my concern is the qualification a little too strict, but that answered it in terms of the federal poverty level.
All right, thank you. Representative Cloran, you have a question? Yes, sir.
Thank you, Mr. Chairman, and thank you for your testimony. My question concerns false positives. I would just like more information on that. And what I've heard is if you have alcohol on your breath or in your system in a way that doesn't impair your driving, that could be a potential problem. So I would just love to hear data or anything you've got. Yeah.
Sure. And Mr. Chairman, Representative McClaren.
Sure.
Again, there is a demo unit outside on the device. And when MAD first started pushing for these devices, the issues of false positives was an issue because it was the old technology. Now, when somebody has an interlock device installed at a place in Georgia, they're taught how to use this device. So if they use mouthwash, they know not to immediately go blow into the device. They know to wash out your mouth and then start it. Now, if for whatever reason, if they had a donut, I don't know, that could set it off. I'm not an attorney, but we hear that excuse. Then again, you wash out your mouth, you go back, and then you do it again. So the issue of false positive, it used to be more rampant than it was, but it's always a concern. That's why, someone shouldn't be penalized for having a false positive, and typically if there is a false positive, they're given time to restart their vehicle. They won't be locked out after just one or two false positives, and there shouldn't be a sanction to that person for doing that.
Sure, because in my estimation, it seems like if the issue is sort of a turning on the machine type thing, that's an acceptable amount of inconvenience for somebody who is subject to this type of restriction, I feel like. But I would be worried about more categorical defects, or if there are any known defects that again are not with respect to donuts or mouthwash.
Mr. Chairman, Representative McClaren.
You're fine. You don't have to
sorry.
try. Yeah.
My goodness, it's still early. I would just say, the interlock, you mentioned the blood alcohol level. It is set at, I believe in Georgia, 0.025, which is what the NHTSA standard set it at. States like Florida used to have it at 0.05. Now they're set at 0.025. States like New Jersey have it at a 0.05 still, but I think they're going to change that. That's just I would say now it's an arbitrary number that NHTSA sets it at, just so that people aren't drinking and driving while they're using their interlock device.
Okay. Thank you.
Any other questions? All right. I want to thank our witnesses today, and thank you, President Woody, for coming and testifying before this committee. As I understand it, the vehicle that was referenced is on Mitchell Street and will be all day today. So if any members of this committee or any of your colleagues in the General Assembly wish to see the vehicle or see how it works, you're welcome to do that just outside of the building. For scheduling purposes, please expect that we will have subcommittees meeting in the afternoon, either Wednesday or Thursday this week. We don't know just yet, but then we'll have full committee Friday morning at 8 a.m. this week. So just to repeat, subcommittees Wednesday or Thursday afternoon, full committee Friday morning at 8 a.m. Thank you. If there's nothing else, we're adjourned.
Thank you.
Thank you.